Yeah, please.
May it please the Court, I'm Sam Vinson from Ungaretti Harris, representing the taxpayers, Rocky Wirtz and the Wirtz Beverage Company. In the spring of 2009, as you've heard, the General Assembly passed 5 bills imposing increased taxes, authorizing video poker, and expending the revenue on both capital and operational concerns of state government. In mid-July, the governor approved them. Within 32 days, on August 25th, taxpayers filed a petition with a complaint challenging 4 of those 5 acts. Those acts violate 3 fundamental rules of our Constitution. Our Constitution prohibits substantive language in appropriation bills. It requires that taxes be levied uniformly on both the objects and the subjects taxed, and it requires that acts be confined to a single subject. It doesn't do that by accident.
Mr. Vinson, can I ask you 3 questions? You can incorporate them into your argument if you want, any way you want.
Yes, sir.
That seem to at least make this a little bit different than the typical single subject challenge. Yes. And I think that'll become apparent in the questions. And tell me what difference this makes, if any. And I'll go through them quickly. The first is this is a once-in-a-decade capital works bill. I mean, by its very nature, it's going to be enormous, right? I mean, there's no dispute as to that. And it contains a variety of creative legislative means to finance it. So the first question is, why would the financial part not be a necessary element of the capital projects bill? The second, these are somewhat related. The legislative history apparently contains not a single accusation of log rolling, which we typically see in single subject. In fact, it appears that the history reveals a rare level of bipartisan unity all around drafting and passing this major capital works bill. And then similarly related to that is, again, in a lot of these single subjects rule-type cases, there's some type of smoking gun, where we see, come on, what's that doing in there? That's the purpose of that. Difficult to pick out one in this. So that's the basic question. Does that impact on the argument at all?
Yes, sir. I think you figured out the 3 most important questions on the case, for sure. And let's go at those. I'd like to go at them, if you will, in reverse order. The smoking gun. There's an absolute smoking gun. There are 2 smoking guns, in fact. The first smoking gun is the $245 million diverted from capital projects to general revenue. And that $245 million is by no means offset by an equivalent $245 million backed out of road funds that have gone previously for operations. First, pardon me, road funds can be paid for operations. The state has not told you that the road funds are going for capital, and the state has not told you that the road funds are not going for operations. They can be used for operations. It says so precisely in 8.3 of the State Finance Act, the road fund section. Secondly, the $245 million that they allege backed out is not $245 million at all. The statute that they passed, and on the face of the statute you can identify it, only permitted $30 million to be used for the Secretary of State in fiscal year 2010 and $50 million to be used by the Secretary of State, by the State Police in 2010. There are maxes in the statute that passed. So in order to get to the argument that the state makes about a $245 million backout, you have to turn legislative history or the law of legislative intent on its nose. What you have to decide, you have to reason that legislative intent is not something that you get from a bill, but something that you get from what the legislature might have done or had done in the past, not something from a bill. There is no $245 million transferred out. Third, The state talks to you about Public Act 9642 in their final brief, and the fact that there was language in that brief suggesting, in that appropriation bill, suggesting that the $245 million was substituted. What the state does not tell you is that 4 bills later, in 9646, an appropriation bill signed into law by the governor, there are numerous appropriations, very substantial amounts, to the Secretary of State and to the state police. You can't define legislative intent from totally different bills because they conflict. There's no ambiguity whatsoever in 9634, the omnibus bill, that had the previous limits. It shows the previous limits that were in law, and it's law that actually compels what can be spent and what can't be spent. So I think in reaction to smoking guns, that's one. The second smoking gun is that both the omnibus and the appropriations bill contained clauses in them that required that they would not go into effect at all unless the other bill went into effect. That is log rolling in the worst way. As, for instance, this court held in the Kirk versus Lindbergh case, the worst situation you can face is late in the budget year, where the things are put into budget bills, into appropriation bills that don't belong in appropriation bills, substantive language. In this case, the language saying that the appropriation bill would only go into effect if the omnibus bill, 9634, went into effect. Now, what that Siamese twin conjoining of these two bills accomplished was it put the governor in a position where he essentially was stripped of his veto powers. He could not exercise the line item veto, he could not exercise the reduction veto, and he could not exercise the amendatory veto to get rid of that language in the appropriation bill. You held that in Kirk versus Lindbergh. Further, if he wanted to get the general revenue money, the $245 million, or conceivably it's as little as $160 million, if you do my $80 million number, if he wanted to get that general revenue money, he had to sign those bills to get it, and he had to sign both bills. He had to sign every project that the legislature wanted, and he had to accept video poker, a vast expansion of gambling that is truly remarkable. Now, I think your second question was a question that there doesn't seem to be any particular problem with the provisions in the bill. And I would say that the linkage provisions are clearly a perfect example of a problem that, a single subject problem. The single subject problem in the linkage provisions is that what it does is it's, as I said, strips the governor of his veto, but it also tells every legislator on the floor that with both of those bills going into effect, they'll get every project they ask for in the appropriation bill. Let me quote to you, just briefly, what the sponsor said. The sponsor said, the four leaders have got together and worked out funding for capital. It's not easy voting for taxes. Quite frankly, there are parts in here I don't want. There are parts in here I would prefer not to be here. Well, Your Honor, that is really the way in which you have defined log rolling. When you put riders into a bill and attach them to something popular and require that the legislature vote on those in total, consider the whole package, and then present that whole package to the governor, you've not only log rolled the legislature and told each member that if he wants the project he wants, or if he wants the source of revenue he wants, perhaps a member wanted video poker, perhaps a lot of members didn't. We know the record on what's happened with video poker.
Counsel, Mr. Vinson, when you said that they were unhappy but you didn't finish, they did all vote for it.
Well, if you're in a position where the only way you can get your project is to vote for the package, that defines successful log rolling.
But doesn't it also define that they were reached through compromise and the goal of putting people back to work, and what the subject, was probably the desire of the legislature to do that?
There are certainly situations where people reach compromises, and in our society they have to reach compromises. But a compromise where you have to vote for things that are unpopular in order to get things that are popular is a mistake.
What test does this court utilize in determining whether or not the legislation is a single subject, relates to a single subject?
I'm sorry, ma'am, I didn't hear you.
What test do we apply? Do we have a test that we look at to see whether or not the legislation is related?
You've applied essentially a germaneness test, whether or not the provisions in the bill are logically connected to the bill. And you've applied that test. Maybe the best leading case is Cutinello. And in Cutinello, what you found was that, yes, a bill can include a provision that naturally supports the purpose of the bill, the single subject. What that was in Cutinello is interesting. Cutinello was a transportation bill. And what you applied that term to, that germaneness ruling to, was the fact that Cutinello required financing. It raised the taxes in order to pay for transportation. But it didn't funnel money off away from transportation to other projects. And it didn't funnel money off away from transportation to the General Revenue Fund and to government operations. It stuck with transportation. All the money went to the RTA, went to state highway authorities, went to the toll highway authority, and went to the local road districts, counties, and municipalities for road use. That is fundamentally different than saying, for example, in what we discussed earlier, or what was discussed earlier, I should say, the question about the study, the University of Illinois study on the lottery. Cutinello could have had an amendment in it that said, we're going to study taxes, the sales tax, to see whether it's too regressive. But it didn't. It didn't at all. And that's not what that ruling was applied to. And I would simply submit that doing studies on the fairness of taxes, the appropriateness of taxes, is certainly not something, and especially when those taxes flow not only to capital projects, but also flow to operations of government, public aid, children and family services, agencies we're all familiar with, desirable things. But when that amendment deals with the fairness of tax, much of which goes to operations, it's not an amendment directly connected to the question of a capital project.
Counsel, do you